Thank you. We are now here in the matter of State of Iowa versus Jasmine Warren. We'll start with the state. Mr. Kodiaga, if you'd like to do a sound check, you'll need to turn your mic on. I want to make sure Justice Appel can hear you.
Good morning, Justice Appel.
He can hear you. Thank you. You may be seated. Ms. Messamer, if you'd like to do the same, and then when the sound check is successful, you can begin your argument.
Thank you, Your Honor. Can you hear me, Justice Appel? May it please the court, counsel. Both the Fourth Amendment and Article 1, Section 8 prohibit unreasonable seizures. A seizure is unreasonable if it's either too long or too intrusive. The seizure in this case was both because it didn't need to happen at all. As the Court of Appeals recognized, it's completely doable to enforce a parking violation by simply leaving a ticket on a person's window. And I think that's standard practice because that's the nature of parking violations. There's also the fact that parking violations are categorically the most least significant violation there is under criminal law in Iowa. So taking those two factors, the triviality of this violation and the lack of need for law enforcement to effect a seizure in order to enforce that violation, those two factors make the seizure that happened in this case unreasonable. Therefore, we're asking the court to adopt a bright line rule whereby law enforcement cannot seize a person to enforce a parking violation unless a seizure is necessary to prevent evasion of the ticket.
Ms. Messamer, would you agree with me that oftentimes there are, for example, OWIs, which are the main charge, and whatever the probable cause or reason for pulling over may not ever have any ticket whatsoever? Doesn't mean that probable cause didn't exist, but maybe the officer felt like, I'm not going to nail him with a speeding, I'm just going to write an OWI. Would you agree on that?
I do agree with that, Your Honor, and I recognize that the court in other cases has said that seizures for any scheduled violation is acceptable, and that's something that can flow out of another scheduled violation. But I think that this case presents an opportunity to draw a line because parking violations are a different category than
That's where I'm
other
going. If an officer can write an OWI and not necessarily write a ticket for the simple leading up to it, wouldn't there be a moving violation? It happened, from what I've reviewed in the record, it happened in his presence. How about stopping in the traveled portion of a highway? Couldn't that have been charged? And that would be moving, right?
Yes, Your Honor, and I think that's distinct from a parking violation.
It's different, but the facts, if the facts are as I understood them, the officer observed the car driving and turned around and then accelerated and then parked halfway in, halfway out of a driveway, which means they are still in the street. So couldn't that have also been a moving violation, but maybe he chose to do the non-moving? I'm
not aware, I guess, Your Honor, of how that would be classified as a moving violation. I'm not as familiar with that particular law Your Honor is citing. But I do think in terms of the example you're saying, if someone parked in the middle of the highway, the line we're asking for in this case is not going to prevent law enforcement from safety checks, from things that present a risk to anyone. It doesn't prevent consensual encounters, things like that.
What about, I mean, there's some parking situations, I'm sure you've encountered it, I've encountered it, where you park your car and you don't realize it, but you're like blocking some alley or something like that. And somebody comes up to you and says, you need to move along. I mean, you wouldn't object to that, right?
No, I wouldn't object to that because that's not a
But then
seizure.
how do you define, how would you define, so you'd say no parking violations except safety ones or ones which might create a traffic issue, or what would be the exclusion?
Well, I think what Your Honor is pointing to there is not a seizure. Just asking someone to move their car, that's not law enforcement forcing them to have an encounter with law enforcement. You're simply saying, address this violation in a way that, move on. That's not a seizure where you're having this interaction with law enforcement.
The problem here is the officer activated the flashers and came up to the car because, as I understand it, almost immediately they start talking, and according to the officer, he detects the odor of marijuana, right?
The testimony in this case, and the initial interaction is not captured on the body camera. So what the officer testified to is that Ms. Warren got out of her car, was trying to get away from her car. He called her back and said, let's get your license, registration, and insurance. And upon her opening her car door, then that's when there became reasonable suspicion or probable cause that there was maybe marijuana use going on. So in this case, it's the initial seizure when she's walking away and he says, come back here, that's a problem. And I think if he would have said, come back here and move your car, then that's it. There doesn't need to be this further interaction between the two of them. He can see that she moves her car and that's resolved. And I think that goes back to.
Counsel, I have a question related to that. If I'm kind of viewing this as a situation of authority, and I think you would agree that the relevant statutes authorize an officer to make an arrest or seize a person under these circumstances. Is that correct?
That is correct.
So he sees a public offense, he's allowed to engage. So given that there's a statute authorizing the conduct, and we presume statutes are constitutional, I guess I don't understand the constitutional reason why a particular category of offenses should be excluded from the operation of the statute. So could you help me with that piece?
I appreciate that. And this ruling would require the court to limit Iowa Code 804.27 in terms of when an officer could arrest someone for a scheduled violation. And it goes back to the Constitution always trumps a statute, and fundamentally, under the Fourth Amendment or Section 8 analysis, is this reasonable and is this proportional? What's reasonable? I think this is an opportunity for the court to step back and say, we've approved of a lot of other law enforcement encounters for scheduled violations, but this is a different class. And looking at parking violations, what's reasonable? Ask somebody to move or give them a ticket. There's simply nothing more that's necessary there.
But couldn't the legislature address, I mean, it's not of a different class. It is classified as a misdemeanor offense, correct?
Correct, but in terms.
So if in terms of classification, the legislature has said this particular violation of the law is a simple misdemeanor, as are all these other simple misdemeanors, we authorize peace officers to seize or arrest people when they see it. So what's to prevent us then at that point, just saying, well, we think there are other classes of misdemeanors that are not worthy of being arrested, and we just start chopping through those?
I think that's a fair question. Yes, these are all categorized the same by the legislature, but in fact, these are a different class. And I think that the court can deal with this class of simple misdemeanors without picking and invalidating different, certain maybe equipment violations as unconstitutional, because that gets into too much of an individual analysis. I don't think that there's as easily of a class for any other simple misdemeanor as there is for this parking violation. And parking violations, I think, are undoubtedly at the bottom of the food chain of enforcement.
Counsel, could we, instead of drawing a bright line rule, find that there was a problem with this particular case, but not maybe all parking tickets or all parking situations?
I think that would be difficult for the court to do I think if there was a route to do that, it would be by saying this was a pretextual encounter. But given the court's holding in State v. Brown last term, I think that that's been foreclosed. But I do think that having a bright line rule for parking violations, enforcement, seizures being unconstitutional fits well with this court's constitutional jurisprudence and what it held in Brown. Because in that case, pretextual stops were the issue, and it was briefed to the court that I think everybody recognizes there's a really significant problem with disproportionality minority enforcement in Iowa. And so in Brown, the defendant was arguing pretextual stops are a large mechanism that exacerbates disproportionality because it allows biases to come through, whether or not they're implicit or explicit. And in that case, the court held pretextual stops are okay, in part because of the practical problems of enforcing a ban on them, because there can be a lot of subjective reasons that are legitimate, and it's difficult to parse out what's legitimate or illegitimate. But equally important to the court's analysis in that case was the fact that Section 8 offers protections to Iowans. And so the court relied on that and said that these additional protections for motorists under Section 8 help limit the potential for abuse of authority that Brown is concerned with reducing. But the result then of State v. Brown is that if you have an equal protection violation, there's no remedy for you in a criminal case. Your protection hinges solely on Section 8. Well, then, I think in looking at cases like this, the court really has to give Section 8 some teeth. It needs to be strong enough to do the heavy lifting that the court is expecting it to do, that the court recognizes it needs to do to prevent problematic pretextual stops. And this case certainly has all the hallmarks of that. We have a black motorist. We've got two officers who are following her before she even commits this parking violation. They both pull in with their lights on, and it's not a normal interaction.
It seemed like substantial show of force for a parking violation. How did you end up with two patrol cars there? Is that in the record at all?
It's not in the record. I would just speculate that this is a heavily policed area of Des Moines. Other than that, I don't know why there were two involved. I think that there's some conversation on the body camera where they're kind of talking amongst themselves and saying they both saw her accelerate quickly, but the officer who testified said that she wasn't speeding. So
I wanted to ask you a question. You said a little bit ago that all he said was, come back. If he'd have said come back and followed it up with immediately, come back and move your car, because it was sticking out in the road, and as I said, that could possibly be another moving violation. But anyway, if that's what he had said, and she opens up her door, and immediately he's hit with that waft of marijuana smell, then what?
I think that's a different situation because the enforcement there is legitimate. Seizing a person to get their identification and insurance and registration, those go beyond really the purpose of interacting with somebody for a parking violation.
So we've broken it down to just his words of come back, stop, and come back here and move your car. That's the difference, is that he didn't tell her in that same sentence to move your car?
Well, I think it's that he says, come back, get me your license, registration, and insurance. So I think that all happened at once. If he would have said, come back and move your car, and then happens to smell marijuana after that, I think that's a different case, because he's not, the seizure is for her to go back to her car and do something in her car, not for her to come back and interact with the officer. So I think that's distinguishable.
Can you address the issue of the sufficiency of the evidence? So I know a lot of this search and seizure issue came up in the Court of Appeals, and there was disagreement about whether it should even be reached on this record. Do we even need to resolve that issue if we can find the error was harmless? Here we have specific findings from a district court judge. Can you comment on that piece?
You're referring to the general verdict?
Yeah.
I think that based on this court's clear case law, you don't look at the sufficiency there. If it's a general verdict, it goes back. And it's for the district court then to look at again. I think it would be a departure from this court's case law on the general verdict issue to change what the Court of Appeals did here. And I also think that this obviously is not going to be a problem in the future because the legislature has said general verdicts are okay now. So I don't think that that's an issue that the court needs to reach, and it also wasn't raised
Have
on
our
further review.
cases on general verdicts dealt with findings from a district court? It strikes me that this is a little bit different in that usually we treat written findings like a special verdict. And here we have a very clear understanding of the reason why the district court judge found as it did. That seems to me a little bit different than like the Hogrief line of cases.
I don't disagree with that, but I also have not thoroughly prepared that issue for today since it was not raised in further review. And I don't think the court needs to reach that, particularly if the court finds, as we're urging, that the seizure was illegal, then that's going to be a moot point anyway. But returning to this issue, I think that the argument here is both under the Fourth Amendment and Section 8, and there's no in-circuit case law on this from the federal courts and no guidance from the United States Supreme Court, so this court's analysis is going to be independent no matter what. I recognize that there are jurisdictions who have said that this type of seizure is okay, and I don't think it's terribly fruitful to get into the various fact patterns of those cases. I think that obviously consent searches, if there's a safety risk, some kind of community caretaking, those are different circumstances that wouldn't be impacted by the court's ruling in this case.
Well, let me ask you about the safety business. I viewed the video and tried to study where the car was located. And it seemed to me, it looked like it was parked somewhat diagonally in a driveway, but it looked like it was extending into the roadway a foot or two. And maybe I need to study it more closely, but that's the impression I got. It's sticking out in the roadway. Was that a sufficient safety concern to make this somewhat different than a overtime parking violation, let's just say, or some other violation?
To the extent that this did present a safety concern, which I don't agree with, but if we were to say this presented a safe concern, still the only seizure that's necessary is to say, come back to your vehicle and move it. There's still no necessity to say, come back and get this information from me so I can run your license and have a more substantial encounter with you. And I think in order for the court to say that this was reasonable, I'm sure everybody's heard the bit about a boiling frog. If you put a boiling frog in hot water, it jumps out, but if you slowly heat it, it doesn't realize what's happening and then it's cooked. Well, I know this court has said seizures are reasonable for any scheduled violation, and then arrests are reasonable for any scheduled violation, and pretextual encounters are reasonable, and it's reasonable in any encounter to ask somebody for license, registration, and insurance. I'm not asking the court to overturn those, but I think that we're at the boiling point here, where this is a step that goes beyond all that, and it's not necessary. It's a class of violations where we can do a bright line rule that makes sense, and so let's say here, let's not have these kind of encounters for Iowans. And though this argument is under both the Fourth Amendment and Section 8, I think there are reasons, particularly under the Iowa Constitution, to say that this is unconstitutional. As I mentioned before, everybody recognizes we've got a problem with disproportionality here. And I don't think it's unreasonable.
You may wrap up.
Okay, I'm sorry. I think it's legitimate to say we need to address the disproportionality problem, and how we interpret Section 8 plays a role in that. And so we need to strictly enforce these protections from Iowans. So based on that, we would ask the court to find that counsel was ineffective for not raising this issue and adopt the bright line rule. Thank you.
Thank you. Mr. Kodiaga?
Thank you, Madam Chief Justice, and may it please the court. The question that this court needs to address today is whether the Fourth Amendment and Article 1, Section 8 of the Iowa Constitution.
Counsel, you need to turn your microphone on, please.
Oh, thank you for saying that, yes. Want to do another sound check quick, sir? Just say something so I know Mr. Justice Appel can hear you.
May it please the court.
He can hear you. Thank you. Would you mind starting over? Sorry.
The question that this court needs to address is whether the Fourth Amendment and Article 1, Section 8 of the Iowa Constitution forbids a police officer from approaching and temporarily detaining a vehicle and its occupant where there is probable cause for a violation of a statute that makes it illegal to park in a certain location. The Court of Appeals got it right by finding that nothing forbids an officer to do that, and therefore, in this case, filing a motion to suppress the evidence would have been futile as an attempt by counsel. Why? Because as a general matter, the decision to stop a vehicle is reasonable where the police have probable cause to believe a traffic violation has occurred. There's no dispute that this was a traffic violation. The appellant can call it a scheduled violation or just a parking violation, but it is a traffic violation. And in Iowa,
Okay, but counsel, why did they need to get a license and registration and proof of insurance for a parking ticket?
Well, as the officer testified in this trial, he saw the violation, they made the stop based on that, which is valid, and they approached Ms. Warren to tell her that she'd parked illegally. In the process, the officer has a routine questions which are ordinary to an encounter like this. They could ask for a license. The reason for asking for a license, for example, would be for the officer to issue a ticket. So it could be come back and move your vehicle, but it could also be, I'm going to give you a ticket for parking illegally, and I need to know who you are. And how do I get to know who you are? By you giving me your license.
Well,
no.
Counsel, can't they, sorry, you go ahead, Justice Appel.
Well, I think I was heading in the same direction. Parking citations are ordinarily issued but based on the license plate and vehicle. You don't need insurance and all that.
Well, the statutory schema for the license, for the parking violation does allow for an officer to either issue it to the driver or to issue it to the owner of the vehicle. Nothing stops the officer from that point for asking for the driver to issue it to the driver. It makes more sense in this encounter where the officer actually has the driver to say, I'm going to issue it to the person who committed the violation, rather than issuing to the owner of the vehicle who may not be, the registered owner may not be the actual driver. So in order to impute blame to the person who's committed the infraction, it makes common sense for the officer to say, by the way, what is your name? And can I have your license so that you don't give me the name of your sister or someone else or a friend, so that I don't issue this ticket illegally? So here, the process which the officer operated was valid. Now, our cases have held in Rodriguez, in Coleman, that the ordinary inquiries based on a stop, a valid stop, would include asking for insurance and other information that the driver will be required to have and carry by law.
So is this case a different case if, rather than observing the parking violation happen, instead the officer laid in wait and waited for the motorist to return to the car at some later date? Is that a different situation than this?
I think in that the temporal proximity of the timing that the court is pointing at that point, I think that would have a different analysis. And that's the Medlar or the Ohio case where the person is lying in wait. Of course, the question then becomes more of, was there a pretextual stop in that case? And then the reasonableness of why did you have to wait all these days? However, so in that kind of a fact pattern, I could see the court saying, yeah, that's not reasonable because of the length of time. But in a situation where the person is in the vicinity of the vehicle, is next to the vehicle, the officer has identified a traffic offense that he's observed, nothing in the Fourth Amendment or Article 1, Section 8 forbids that officer from stopping that person and issuing that ticket.
I'm just going to ask you a question about the practicalities. I mean, obviously, the most important thing is what does the Constitution require? But would it be practical, and it seems to me maybe it would be, to just say, as Ms. Messamer asks, that you can't, a parking violation in and of itself is not a sufficient basis for detaining a person for a stop, but you still have your community caretaking authority. So in a situation where there's a community caretaking issue, there's a safety problem, or you're parked in an area that's going to impede the traffic or something like that, you can still go get the driver to do that. Wouldn't that be workable? I'm not saying it's constitutionally required, but wouldn't it be workable?
And the state wouldn't dispute that, and that could have happened in this case. The only reason why we're here is once the officer approached Ms. Warren and said, hey, you've parked illegally, the officer started noticing indicia of Ms. Warren being intoxicated. If that would have been the case of Ms. Warren not having any signs of intoxication at that point, the officer might have just as well said, move your vehicle and move it on. So the stop moved into another issue, and that's what brings us to this court. But the state does not deny that that would have been practical. But in as much as it's practical, it doesn't mean that there's a violation of the law if the officer chose at this point. The officer could have arrested Ms. Warren. Nothing would have stopped the officer from saying, by the way, you're under arrest for parking illegally. We know that Altwater, the city of Lago Vista does allow that. So there will be no violation of the Fourth Amendment for that. Now, the appellant does point to two cases.
I'm
Again,
getting some messages up here. Could you stay close to your mic so Justice Appel can hear you? Thank you.
the appellant does point to two cases, one from Ohio and one from Minnesota, and those cases are readily distinguishable. They're distinguishable by the facts of those cases. If we go to the Ohio case, it was a pretextual stop that was made way before Wren was the law. It's a 1994 case. Wren comes in 96. And so I could see why the Ohio reached that conclusion without Wren becoming the law at that point. Same to the Minnesota case, which is again readily distinguishable because in Minnesota, the violation had already been enforced, the encounter was already over, and a ticket had already been issued, so the officer had no reason stopping the driver in this particular case. Those are not the facts in this case at all. And again, it's critical to point out that in this particular case, the investigation immediately morphed from one form of investigation to another form of investigation. There's no evidence that these officers were sleuthing through, that they were just looking for something else or trying to find something else. Now, I would say that I noticed this court's concern on the issue of disproportionality in law enforcement, especially as it occurs with minorities. The events of this summer make that clear that that is an issue of concern for us. However, our sensitivity to disproportionality should not make this court ignore the record in this particular case. In this case, there is no record that we have that Ms. Warren was stopped because of her status as a minority. We do know there are two police officers.
Counsel, let me refer you to, admittedly, a dissenting opinion in the United States v. Johnson. It's a parking violation case, and the dissenter said, parking violations are de minimis, they're common, and if we allow seizures as a result of minor parking violations, we end up with a general warrant, and a general warrant can be arbitrarily exercised. And as your opposing counsel points out, we don't have a pretext argument under Brown. So if we're going to tighten up at all, it's going to be on the front end, if you will, of the seizure. And the dissent suggests that this is in Johnson, this is a proportionality problem, because if we allow seizures broadly and generally, that will permit disproportionate treatment. So what's your view of that?
Well, I do read the dissent in Johnson, and I do look at our case law in Iowa, and I look at the statute here. This statute allows the officer to make a stop. The stop has to happen either because the officer has reasonable suspicion or probable cause. Here we are talking about probable cause. So it's not a general warrant situation where officers can willy-nilly stop anybody without any probable cause for a parking violation. However, if an officer finds that someone has parked illegally, it's not legal to park illegally. The officer will only be enforcing the law by saying, you have parked illegally, and I can either issue you the ticket if you're there, and if you're not, if you're present and you're with the vehicle, I can, or and if I have nothing else, the law also protects the driver by, if the officer has no other reason to inspect your car or ask you other questions that are not related to the stop, then the law stops him from doing that. So Coleman and Rodriguez are very clear on that. So I don't believe that we end up in a general warrant where officers are just running amok and giving and stopping people. And the record here does not support that either. I'll briefly talk about what Justice McDonald had raised in regards to whether the sufficiency of the record and whether the appropriate resolution is to remand for a new trial. I do believe that what this court should do in regards to this verdict in this particular case is to send it back to the district court, to make the district court make a conclusion based on the subsection that was violated. In this case, there was a good finding of facts by the judge. There's a record of the finding of facts. And we are here as a general verdict situation only because the judge did not assign subsection A to the 321J violation. So what we are asking is this court will remand it, give the district court an opportunity to look at the record to find that this is different from jury cases in Tyler or in Hogrefe or Thorndike line of cases where the jury does return a general verdict, the jury is not there, the record is not static, we can bring back the jury to decide what the case is about. Here the judge can look at the record is static, it's going nowhere, and look at the same finding of facts and see that, yeah, in his finding of facts, he actually found her guilty for violation under the driving while under the influence prong. And based on that, the judge can enter a finding and find her guilty under that prong and reject the prong C, which is not supported by any evidence in this case. So we'll ask this court to look at Ivan, State v. Ivan, which is a Court of Appeals decision that the state cited in its brief, which had that resolution, and move away from, I know Myers, this court actually sent it back for a dismissal. And the Court of Appeals did remand under Tyler. But Tyler, again, was a jury trial. It's distinguishable in this case. And so we'll ask that that will be the resolution in this case. Because counsel would not have won if he'd made a motion to suppress under the facts in this case. Because the stop was supported by probable cause, we'll be asking this court to find that counsel could not have been ineffective on this record, and we'll ask this court to affirm the verdict and remand for the district court to enter a proper verdict. Thank you.
Thank you, Mr. Kodiaga. Ms. Messamer?
I'd like to begin by addressing the state's argument that it's reasonable for an officer to seize someone to make sure they're writing the parking ticket to the right person. I think that argument has appeal when you just think of it at first blush, but if you really dive into how these cases work with parking violations, we're talking about a very de minimis problem here. First of all, you have to separate out all the people who are giving parking violations who aren't even by their car, which that's, I think, the standard where you don't have the person still at the car, so you just write it and put it on the windshield.
I'm going to pick up where Justice Appel was saying, though. There's the kind of parking violation where you're parked in front of the donut place too long, maybe you have a meter or whatever, and that's a parking violation. But you're not in the way of anyone. You're not going to probably cause an accident. Isn't that different than the parking violation that we saw here, or we're listening to today, where the tail of a car is sticking out in a street?
Yes, I would agree those are different in degree, but both of them are extremely minor and can be enforced either by telling someone to move or...
One involves safety.
And telling the person to move their car would address that safety issue when there is the person actually present on the scene. Even if
What about a case where,
Under community caretaking, if it's valid community caretaking, you're allowed to make a seizure, right? You don't have to
I
just
still-
tell the person. You can actually activate the lights, right? If it's valid community caretaking.
Yes, but I think community caretaking turns on more of analysis of the individual facts. And if the intrusion goes beyond what's necessary for the community caretaking, then it would still be unreasonable. And here, seizing someone and making them get their license, registration, insurance, that goes beyond what's necessary for community caretaking. Having her move the car is what's appropriate. And say that this violation did present some safety risk and Ms. Warren happened to make it inside and they didn't bother getting her out. The state would have to wait 24 hours before they can tow her car. So to say that they
what about a different fact pattern? Let's say somebody stopped their car in the middle of 235, which is going to be a violation, I think, of this same ordinance or same statute. Is that a different case than this case? And if so, how does that affect your argument that all parking violations should be treated the same with a bright line rule?
I think that this court can carve out parking violations that create a safety risk. I think that's easy to carve out, and that still leaves the vast majority of cases where there's not a safety risk. And a court could look at those factors and decide. A district court could look at that quite easily and say, was this a safety risk or not?
So that's not a bright line. You were wanting a bright line with non-moving versus moving. There's an example where it's not a bright line, correct?
What about parking in front of a fire hydrant?
Again, I do think that falls easily with a bright line of a typical parking violation does not warrant a seizure unless an officer can say there's a safety concern, or all the other exceptions that we give officers in any other case that they're capable of making those determinations.
What
What
about the point that Mr. Kodiaga made that if there had been an objection below, that's one thing, but we're in ineffective assistance territory, and now we're talking about some fairly fine legal distinctions. Is it really ineffective of trial counsel not to anticipate these arguments and distinctions?
At the end of the day, I think that turns on if this court agrees or not. If this court ends up agreeing and adopts a test that says parking violations can't be enforced with the seizure unless there's extenuating circumstances, special exceptions, then yes, I think counsel isn't effective. I think if you're a criminal defense attorney and you don't look at this case and think this is kind of weird and delve into that, I think that that's not okay. I think that these facts are enough to trigger someone to think about this issue enough to raise it before this court. The fact we're here on further review having these discussions, this is a legitimate issue, and it does implicate significant liberty interests of people. I don't think it's a boogeyman to say that this gives law enforcement a tool that they don't need, that has the ability to be used, is usually used only pretextually, And that can increase disproportionality in Iowa. And
Ms. Messamer, did your brief include anything about a distinction between safety and non-safety, or was it just a bright line moving versus non-moving?
I don't believe that it was set out that way in terms of like how to define the test, but we did talk about cases and acknowledge in the brief that some of the other cases from other jurisdictions, there was more of a community caretaking concern with somebody's legs hanging out of a car, things like that. So those issues were touched upon in the brief, although I don't think that I specifically defined a case to exclude those things. But I appreciated Justice Mansfield's comments in the prior argument about we shouldn't compartmentalize how we're looking at constitutional issues. And here we've got a real problem in Iowa of disproportionality, and it's troublesome that we haven't been able to address the problem that's happening in the court system by means of the court system. And this is an important way to say, no matter what your race, it's unreasonable to seize someone when there's no seizure necessary, but particularly when we have these issues with disproportionality, this is a reasonable limitation that flows directly from the text of both constitutions that this court should adopt. Thank you.
Thank you. The case of State versus Jasmine Warren is hereby submitted. We will take a brief pause for, once again, a changing of the guards, and we will move forward with State versus Patrick Barrett Jr.